Okay, so today I'm going to share firstly 2024 IP statistics, so you understand the IP landscape in China and how other European countries filing in China look like. And following that, we will update around 4 new laws and rules in China related to IP, different types of IP as well. And if you are in the practice or consider filing, protecting, enforcing your IP rights in China, what should be the new consideration for your IP strategy? This is the statistics of different types of IP filing in China last year. And on the very left side, you can see different types of IP. And if you look at it, you will notice that most of the filing numbers in China has been increased last year. Let's go into different types of IP. For invention patent, it has continued to increase not only last year, this year, but over the recent years. That shows the technology developed in China. And for utility model, it's unlike the previous years, the number of applications has increased in 2024. However, if you see the grant number, you will see a decrease. That's because the examination criteria of granting utility model has become more and more stricter. That's why the number of the grant of utility model has dropped. And the number of industrial design and trademarks continue to decline. If you look at the application, however, the grant number has decreased. But the decreased rate of industrial designs and trademarks has been slowly than before. And the number of the copyrights registration has increased significantly, and not only last year, but also the previous years. The copyright registration in China include works like the images and like the books and the others, and as well as the computer software, and both of those types of copyright registration have been increased. And among all the European and single market program countries that file the most IP application in China, you can see here for different types of IP. But you can find that some of the countries that are commonly come out, like Germany, France, the Netherlands, Sweden, Italy, and Spain. Those countries are actively filing and protecting their IP in China. And in terms of GI, geographic indicators, GI can be protected by 2 ways in China. First is the collective marks and certification marks. Second is the GI products. And France take the majority part of the filing in the previous years, including last year. And besides France, Italy, Spain, Germany, Portugal, and Greece also actively protecting their GI in China. And as some of you may know, China Custom, China Custom, or the full name is General Administration of Customs in China, GACC, they monitor and detain those infringing, especially IP infringing products, export to China and import from China. And last year, they have detained more than 40,000 suspected infringing products. That's including import and export. And among all these infringing products, 99.5% are related to trademark infringing products. That's an absolute majority of all the infringing products. And if you look at the application for IP recorders, what does that mean? That means if you have trademark register in China, protection in China, you can inform the GACC that you have this trademark right, and they should monitor any goods bearing your trademark, import or export for you. And this is an action we always recommend European company to do in China right after they have trademark, copyright, or patent rights registered in China. And last year, the GACC has accepted more than 29,000 applications and approved more than 20,000 IP recorders. And you will see actually more than a quarter of the approval recorders are from overseas applicants. And we are continuing to raise the awareness of using China customs. And but this shows more overseas applicants pay more attention to use the customs in China. And one of first new law and rule I want to update with you is the Anti-Unfair Competition Law. Many foreign companies are not familiar with this law. Actually, Anti-Unfair Competition Law prohibits acts like trade secret infringement. And in China, there is no trade secret law. But if you want to protect your trade secrets, or if you want to enforce your rights after your trade secrets infringed, you can always refer to Anti-Unfair Competition Law. And now this amendment, it's the third version of the amendment, and it was only issued this year. It's still very new, and it will be effective from 15 October of 2025. So it leaves all the companies a couple months to prepare for the compliance of this law. Some highlights of the amended unfair competition law, anti-unfair competition law include they make these laws make it more clear of what is unfair competition acts. That includes commercial bribery, false advertising, improper price link sale, and commercial defamation. And this the new law also highlight what is online unfair competition and make it more clear, especially in the context of e-commerce platform or the online economy. Like Article 7 includes setting other sites as search keywords to mislead or confuse the market as one of the types of online unfair competition acts. Before that, it's still in the gray area whether or not setting someone else's trademark as search keywords and leading to the infringing link, whether or not it's illegal or it's against any law. But now it's very clear that's against the anti-unfair competition law, and you can enforce your rights if you are the right owner. And the sites I just mentioned include trademark, trade name, online usernames, social media account name, made part of the domain name, as well as the software or apps name. So you can see the Online Unfair Competition Act has been extended, and that will help to increase the healthier and also more healthier and better functioning online market in China. And if you read Article 29, you will see that the maximum fine for online unfair competition practice has been increased from 3 million RMB to 5 million RMB. 5 million RMB is around 600,000 euros. And the new law also adds provision to address unreasonable payment terms or overdue payment to SME. However, pay attention to the SMEs here. It doesn't mean all the SMEs around the world. It only refers to the SMEs established in China, including joint venture and wholly foreign-owned enterprises. If you are still just based in Europe or if you don't have any branch or entity in China, you may not be applicable for this article. And Article 40 make it clear that the anti-unfair competition law has extraterritorial application. What does that mean? That means any unfair competition acts committed outside of China, mainland China, that disrupt Chinese market shall be handled according to this law. It could potentially regulate bad faith trademarks registration abroad and trade secret infringement abroad. However, but it has the impact in China. We do not the details of what does the extraterritorial application means yet, but there will be more cases in practice to be released, and we will have a better and clear understanding of this article. However, this law does not address unfair competition issues related to AI, artificial intelligence. And the second law we are going to go through is related to patent infringement. In China, in addition to patent infringement litigation, you can also choose various alternative dispute resolution methods, such as mediation. And this law is focusing on this new rules is focusing on the mediation. The highlight of this law, including what kind of case type, what kind of case they are deal with, mostly about patent infringement disputes, and the authority to deal with the mediation is the Patent Administration Department, including the CNIPA, which is China National IP Administration, the Central IP Office, as well as the local IP office. Most of the time, it will be the local IP office handle the case. And in this new rule, it also make it very clear that if one of the party is foreign entity, and or those evidence was collected overseas, those documents should be notarized and certified. And it makes it very clear that apostille can be accepted. In the past, 3 years ago, before 2023, 2 years ago, the apostille was not accepted in China. That means you have to go through a very long procedure to have your documents notarized and certified, especially because the document has to be certified or legalized in the embassy in your home country, Chinese embassy in your home country. But now the apostille make it very fast to get all the documents notarized and certified outside of China. Mediation is not new solution in China. What's new, according to the rule, is that if the IP office help both parties to reach a settlement agreement, it can be notarized. That allows the patentee to apply for an enforcement later on in the court. And also, it set a very clear time period. That means any mediation case has to be concluded within 3 months, and it could be extended twice. And include if the case was extended twice, it still should be concluded within 6 months. That's so much faster than the traditional litigation case, a case which usually can last for 2 or 3 or even more years. And also one thing I want to mention is that before the new rule, the mediation conducted by the local IP office usually was used as the evidence collection. Because the IP office, they have the authority to conduct the investigation to help the patentee to collect the evidence related to the patent infringement case. However, this kind of procedure can last for long. And the negative part of this procedure is that local IP office usually tend to persuade the patentee to withdraw the complaints rather than concluding the mediation procedure. And with this time period, we hope to see that the mediation could be a tool to collect the evidence, not only to collect the evidence, but also a more reliable and efficient options for patentee to collect the damages. However, based on some latest cases, it still shows that different provincial authorities are applying the mediation rules in different ways. That makes the procedure less predictable. And the next rule is about trademark. It's about non-use cancellation of trademark. In case some of you may not be very familiar with this procedure, non-use cancellation is a method to challenge trademark registered in China for over 3 years. And the ground for this challenge are that the trademark has not been used for the past 3 consecutive years, which leads to a waste of market resources. As you may know, there are millions of trademarks filing in China every year. And if those registrations are not used, then why they are there to take up the trademark right? And non-use cancellation have been a tool frequently used by the right owner when they discover that someone else had registered their trademarks in bad faith, or when existing similar trademarks block their trademarks registration in China. If some of you have a consultation with me or have asked me about how to register trademark in China, after doing a trademark research, when I find out some similar trademarks, I may already suggest to consider a non-use cancellation against those trademark who has been registered for over 3 years. So you may be more familiar with this procedure. Anyway, so what is the new rule bring to the practice? It set a stricter evidence requirement. So this is here we can see a list of the documents you need to provide to start the non-use cancellation. First is the trademark owner's business scope or operational status. Second is the applicant's identity. If you are the one who decide to file the non-use cancellation, no matter you're a European company or Chinese company, you need to provide that. And in the past, these identification documents could be provided by a straw man's, and that means the whole non-use cancellation will be filed anonymous. But now it's not likely anymore. You have to provide your real identity, and we will go to detail of it later. And the third evidence requirement is the evidence of online investigation, because you are going to claim that trademark has not been used for 3 years, you have to provide the evidence such as your search results in e-commerce platforms, social media, and even the industry reports, indicating that trademark has not appeared in any of the online research. And the biggest change is the evidence of on-site investigation. It does not apply to all the case because it only requires when the CNIPA requests you to do it. That will be potentially more costly for the person or for the entity who filed the non-use cancellation, because it will involve investigator who is going to conduct the online investigation, and it's not cheap in China. The last one is the declaration letter. That means you acknowledge penalties for false submission and confirm accuracy. That also is used to stop the anonymous filing of the non-use cancellation. So I already mentioned that the new rule banned anonymous filing. In the past, the applicants could file the non-use cancellation without revealing their identity or using a straw person's identity, which is a strategy used to avoid retaliation from the trademark owner. And the rule mandates the disclosure of the real applicants. That it's actually in line with the CNIPA's crackdown on bad faith non-use cancellation. And what does this new rule mean to EU SMEs? First, non-use cancellation could be more costly. Like I said, if it has to involve on-site investigation, then you will have to hire a local investigator to finish the on-site investigation. Sometimes it goes to the trademark owner's factory or their physical shops, and that could involve the domestic flight in China. And that's one of the impact you should consider. And the retaliation from the trademark owner is higher since the anonymous filing is banned. That's the biggest concern from the applicants who want to file non-use cancellation. On the other hand, non-use cancellation was so easy to use that they were exploited to target the legitimate trademarks owner, such as European EU SMEs in China. And to defend the trademarks rights against the non-use cancellation, European SMEs must collect evidence of use and hire a lawyer to prepare the documents, as most non-use cancellation were filed anonymously. It was difficult to trace who started the petition. Banning anonymous filing is likely to reduce these types of malicious filing against European SMEs trademarks. So yeah, these rules bring more cost if you want to file a non-use cancellation, but it also reduces the malicious non-use cancellation, most likely from Chinese company to European companies. And the last law is about the new variety rights. The new variety of plant regulation, this law is to protect the plant variety rights. And the Ministry of Agriculture and Rural Affairs, as well as State Forestry and Grassland Administration, are jointly responsible for administering plant variety protection. They accept and review applications, grant rights. Currently, it's free to register the plant variety rights. And as rights owner, you need to register your rights in China to enforce it. Therefore, you need to refer to this regulation to see how to register your rights in China. And the new regulation extends the protection term of variety rights of vines and forest trees from 20 years to 25 years. And for other plants, it has been extended from 15 years to 20 years. It's still a bit shorter than European, but it's less shorter. And the new regulation also sets that preliminary examination should be shortened from 6 months to 3 months. What does this preliminary examination means? That means those administration offices, they have to check whether or not the name of the new variety of plant is proper, and whether or not they should grant the right to you. Whether or not the variety is new, they will check those criteria before they grant the right to you. And to increase the enforcement efficiency in China, the new regulation also set the maximum penalty for infringement has to be increased from 5 times the value of the goods to 10 times, with an additional minimum fine of 10,000 RMB. Those are the legal updates from earlier this year. And if you are considering protecting your IP right in China, or if you are already in China and considering updating your IP strategy, here are some considerations. First is about patent protection. Some of you may be aware of the dual filing. Dual filing is a filing strategy of invention patent and a utility model. For the same technical solution, you have the right to file an invention patent and a utility model on the same day in China. That it's a good strategy to combine the shortened examination period for utility model and a longer protection term of invention patent. If you get both rights, invention patent and utility model, you will have to abandon one of them, because for the same technical solution, it's not allowed to have 2 grantee rights in China. However, there is some new challenge. I may already mention that the granting criteria for utility model and has been stricter, and the requirements for an inventive step for invention patent has been stricter as well. That means getting the rights for utility model is not as easy as in the past. So here are some alternative or some updates from our IP experts when you decide to protect your technical solution by using dual filing. First, you can consider filing utility model application with narrower claims. And when you file the invention patent, you can still file on the same day, but with broader or different structural claims. By using this alternative solution, you will either get one of the rights or both of the IP rights. And if you are lucky enough to get both IP rights, and because they have different claims and technically they are not the same technical solution anymore, so both IP rights will exist for the same technical concept. And if your company is related to technology like software or apps development, you may consider the data protection in China and pay more attention to cross-border data transfer. And cross-border data transfer and NDA, they are more relevant than EU because the law in China and in EU are different. Sometimes if you didn't realize the conflict of the data regulations between the EU and China, it may cause the unenforceable NDA clauses. Just an example, the EU AI Act, Artificial Intelligence Act, requires algorithmic transparency. That means you need to disclose the training data source. However, China's data security law prohibits the exports of important source code. And if your technology is developed in China, it might be difficult for you to bring the training data source to Europe, unless you pay a lot of attention to comply with the China cross-border data regulations. And Chinese regulation on protecting the data and resources in China could also influence IP registration. The data related to the genetic resources will need to be disclosed to CNIPA, just an example. Otherwise, the patent application using such data could be refused to be deemed to have been withdrawn. And another example, submitting the patent and trademark application from China to overseas authority does not require compliance with the 3 regulatory pathways of cross-border data transfer. Those 3 methods I just mentioned include security assessment, standard contractual clauses, and personal information protection certification. To get either of them, at least for now, it's not that easy and you have to wait for a long time. But like I said, the application from China to overseas, you do not need to go through any of this way. However, if the transfer content includes technical secret source code or undisclosed R&D data, and those data are classified as important data by relevant authority, then you may have to get the security assessment. And that will take a lot of times and a lot of communication. You may get involved with a data compliance expert to give you advice in this regard. And some of our experts suggest that European SMEs consider making classifications for data undergoing cross-border transfers and ensure their compliance with the Chinese law. How to classify those data? Here is just some suggestion. You can classify as personal information, important data, or core assets. Personal information that includes employees, customer data, to ensure the personal information protection law in China has been complied by using one of those 3 pathways I just mentioned, unless there is exemption. And the second classification is for the important data, which is technical specification. And such data may require localization. So in the contract or the NDA, you should put clauses such as only anonymized data might be shared or on-site access within China. And for the core assets, use a comprehensive strategy to protect those, such as NDA or copyright registration and patent registration to protect different part of the core assets. I also want to focusing on the software IP protection, because this a lot of more and more companies in software related sector has come to me and ask about how to protect software in China. And one of the biggest difference between software IP in China and Europe is patent protection. In China, it's possible to patent your software, but not all the software can be patented. Only those software which solves a technical problem, use technical means, and achieve a technical result can be patented in China. And here are 4 examples of those software which can be protected in China. Computer program for industrial process, that's the first one. Second one, the software is to improve the internal performance of computers, and the software is to use for control, measure, or testing process. The software is to process external data. If you are not sure whether or not your software is one of those 4 types of software, you can always consult with a patent attorney in China. Actually, whenever you want to protect patent in China, I will recommend you to talk with a patent attorney to get more details and have a better strategy of filing in China. And the second IP, which has been used more commonly in China as well as Europe, is the software copyright. Because China and all the European countries are part of the Berne Convention, that means if the software is created in Europe, you can get the automatic protection in China. And if you already get the automatic protection in China, then why should you still consider registering it? Because after the registration, you will get the the Chinese registration certificate. That will be very helpful when you enforce your rights in the situations such as software piracy. And it's free of charge to register your software copyrights. It only takes 60 days. But if you involve a an IP attorney to help you to register the software copyright, then you will still need to pay the attorney fees. The protection term is 50 years. And remember that the software copyright protect the source code, but it does not protect the core idea behind the source code. Like if someone changed the source code library and develop a very similar software, it might not be considered as software copyright infringement. Consider using different IP to protect your software, like the patent I just mentioned. If you go with the registration, the authority is the Copyright Protection Center of China. And another important IP type you should consider is the trade secrets that protect the unpublished data and source code as well as documents. So how to protect those information as trade secret? First, categorizing those business information as confidential. Second, control the accessibility of important documents. Only provide it to your employee or your partners according to the need-to-know basis. And implementing robust IT security infrastructure, as well as a trade secret protection policy within your company, making sure your employees understand your expectation. Most of the time, it's your employees or the employees of your partners who leaked those trade secrets information. And regularly review the external communication and use the contracts as well as the NDA, the non-compete agreements to protect the trade secrets. And do not forget the trademark and industrial design. So for the software brand name, software name, you can consider to register it as trade secrets, and always consider a Chinese name, Chinese brand name, if you decide to come to the China market. And remember to conduct a trade secret, the trademark search before registration. And if you develop a very unique graphical user interface, you can protect it as industrial design in China. And this is rather new in China. It's only been available in the past few years. So use this system smartly, and it will help you to protect, it will help you to get the exclusive right to use the graphical user interface under the industrial design system in China. First takeaway messages, IP laws and rules develop constantly, so keep yourself updated. You may consider ADR, alternative dispute resolution, in addition to the litigation, in the event of IP disputes, and update your trademark and patent strategies. Especially pay attention if you want to file non-use cancellation against other trademarks. Remember, those trademarks have to be registered for 3 years. Or if you want to protect your patent in China and consider using the dual filing system. And always consider the data regulations when protecting your IP in China. Decide a comprehensive IP strategy for your software. And if you have any question, or if you encounter any IP infringement, or if you need suggestion on IP filing strategy, always consult IP expert or contact us.